The first matter to come before the court this morning is State of Ohio versus Matthew McClain. The state has waived oral argument. You will have 15 minutes to present oral argument this morning. We have read the briefs. We're ready to proceed when you are.
Very good, thank you.
Thank you.
May it please the court, my name is Christina Reihel. I am here representing Matthew McClain, the appellant in this matter. Now, after reading the briefs in this case and receiving the supplemental authority that was provided by the state to the court, I'm sure all three of you are wondering, why in the world am I still here arguing this case? Isn't this case right here, State versus Richardson, doesn't this solve everything? Unfortunately, it doesn't. This particular case is very distinguishable from the case before the court for several reasons. As the court is aware, the case before the court, it's an OBI matter. We're talking about a young man who was pulled over at night. It was windy, it was rainy, he was cold. The officer was trying to determine whether or not he was under the influence of a drug abuse, such as he did admit to using Adderall. He also had admitted to using marijuana, but not for at least 2 weeks, and the officer did eventually locate marijuana in his car. The officer also noticed some signs of impairment, such as a lack of balance. He had problems doing the field sobriety tests. That was primarily the lack of balance, as well as the HTMT test. He did notice he counted all of the points in the HTMT test. He also noticed that Mr. McClain's eyes were glassy, but they were not bloodshot. His language was not slurred. And beyond that, the reason he was pulled over was twofold. One, because an unidentified individual had stopped and told the officer, "Oh my goodness, this guy just tried to run me off the road." So a diligent officer, he follows him. He waits and he sees what he believes is a left of center violation, so he pulls him over.
And the left of center violation is not reflected on the video, is that correct?
That is correct, Your Honor. The video is rather grainy, and because of the rain on the windshield, it is very difficult to determine whether he actually does go left of center or not. And beyond that, the state actually dismissed the left of center violation before trial, so they didn't even seek to find him guilty of that. They decided that, I don't know whether they decided there wasn't enough evidence or it's just a minor misdemeanor, why are we worried about it? We really want to focus on the OBI. But they did dismiss that one. So this case, in some ways, is very similar to the Richardson matter in that the State versus Richardson case that the state had provided to the court is a case about, do you have to show what specific drug of abuse this person was under the influence of? And do you have to have expert testimony linking that to the actual signs of impairment that you see in this particular individual? The problem with using Richardson to say, oh, this is answering this question in this case as well. First of all, Richardson was very specifically decided as a sufficiency of the evidence case. And although this might seem a little nitpicky, the court was very clear that somebody had tried to certify this as a conflict. And they had tried to certify it as a conflict with a case from 2006, which was a manifest weight claim as opposed to a sufficiency claim. And after the court looked at the merits, they said, you know what, this really isn't a conflict because we're only looking at sufficiency, we're not looking at manifest weight. In my case, I'm looking at manifest weight, so it's different there. The court also sent it back. They sent Richardson back to the appellate court to determine, now that you have this guidance from the Ohio Supreme Court, now look at your manifest weight claim again and decide that one separately for sufficiency. So it takes it out of the confines of that, basically on a technical point. But the bigger problem is that Richardson very clearly states that the Court of Appeals erroneously concluded that you needed expert testimony to link the ingestion of a drug with the impairment. And they said, no, you don't need expert testimony, that there was an officer in that case who said and testified as a layperson that the type of drug that this person ingested, admitted to ingesting, suggests that the impairment goes along with that. So I would expect somebody who had ingested, I think it was hydrocodone in that case, to show the kind of impairment that this young man in Richardson was showing.
In other words, the effects of that drug are well known to everybody.
Correct. The effects of that drug are well known to everybody. We know that if you take hydrocodone, you're going to show that impairment that the young man in Richardson was showing. The difference also in this case is that there's no evidence. There are two drugs that were discussed in this particular case for Mr. McClain. One of them is marijuana and one of them is Adderall. Mr. McClain told the yes, I am taking Adderall, though there was nothing else established as a prescription, is he using it? There's no evidence as to any of that, and there's no evidence as to when he took it last, but he does say, I take Adderall.
Can we back up just a second? You said there's no evidence that there's prescription or he was misusing it. Whose burden would that be?
I believe that would be the state's burden to show that you were abusing it, because you have to show under the law.
Okay, so let's take the abuse out. What about the prescription?
You're right, it would have been helpful for the defendant to testify to that, but the officer didn't ask. And I guess then, I understand where you're coming from, Judge Carr, that, well, let's just assume for the sake of argument, he didn't have a prescription, so therefore we can't assume he's abusing it. Even if we assume he's abusing it, there's one more step that's missing in this case, and that step is, there's no testimony of any sort saying that the effects of Adderall would mimic the impairments that he was seeing, which were the lack of balance, the slurred, not the slurred speech, but the glassy eyes, the lack of balance, and the fact that he's shaking, that his hands are constantly moving. The officer basically says, I don't know what the effects of Adderall would be on somebody. The officer couldn't even remember whether it was a stimulant or some other sort of drug. And the prosecutor had to say, well, would you be surprised to know that this is a drug under, I think it was Schedule 2? No, I wouldn't be surprised if that's the case. But the officer couldn't say what kind of drug it was, what effects it would have as a layperson or otherwise. So there was no evidence that the type of impairment shown was indicative of Adderall use. And likewise with the marijuana, that's the other suggestion in this case, is was he under the influence of marijuana? Well, the officer also testifies that one of the symptoms and signs of impairment under marijuana use is going to be you're going to have red eyes. He didn't. He did not have light eyes, and they actually, bloodshot eyes. The defense attorney actually specifically pointed that out because the prosecutor tried to say, and wasn't it true that he had red eyes? And the defense attorney in Jackson says, wait a minute, that's mischaracterizing the evidence. There's no evidence that his eyes were red. They were just glassy. So that's...
My memory, was there anything in the record that indicated when he last used marijuana?
He told the officer that he had last used marijuana 2 weeks previously. So beyond that, no, there's no additional evidence other than, yes, there was marijuana found in the car, but there was no odor of marijuana. So this officer didn't come up and say he smells like marijuana. He didn't say that he was acting in accordance with somebody who was under the influence of marijuana. He just basically said, I found marijuana. He admitted to using marijuana at some time in the past, and so I believe he's under the influence of something, but I'm not sure what.
Thank you.
So that is one of the big differences in this case between Richardson. Is Richardson basically stands for the proposition that you don't have to have an expert testify, you just need some evidence, including from an officer testifying, here's the drug or the class of drugs we think was abused. And in this case, the type of impairment I'm seeing is what you would expect from that drug. You need that second step. And in this particular case, we don't have that second step. That is entirely missing because the officer doesn't even say, yes, somebody under the influence of marijuana I would expect to act the way I saw him act. The officer never says that. So we don't know if this would be consistent with those types of drugs or whether it's consistent with you've got a young man in the dark who tells the officer that he thinks he's being chased by somebody. So it's windy, it's raining, he's cold. He tells the officer, I'm cold, can you drape something over me because I'm shivering, I'm freezing. Yes, it's in June, but the officer says, well, I wasn't cold. Well, the officer may not be cold. This young man, he probably has a different body type. He's probably not in the same physical condition as a state highway patrolman. He very well may be getting cold. Maybe he hasn't eaten for 8 hours. Maybe we don't know why. We know that he says, I'm cold, I think somebody's chasing me, I'm afraid, I'm scared, I'm anxious, I don't know what's going on. And so the signs of impairment he's showing can also be indicative of all of those things as well.
What about when he indicated that he had missed a curb and hit the guardrail?
Yes, he did indicate to the officer that he missed a curb, hit a guardrail. The officer had noted the damage on his car, and the officer mentioned he had no idea whether he had hit that guardrail that night or if it was previous. He knew because there was no rust on the damage that it couldn't have been really old and that it was fresher, but he wasn't sure whether it was that same night or some other time. And missing a curb, even if we assume that this young man hit that guardrail that night, officer said he couldn't find a guardrail with damage in the area, so he didn't know. Even if we assume for the sake of argument that he hit the guardrail that night, you still have a wet road, you still have windy conditions, you still have somebody who's afraid he's being chased. So the fact that somebody grazes off or hits a guardrail under those circumstances is not necessarily, it's not a good thing, but it's not necessarily surprising. The other thing that I think is important in this case, just to mention, is that there was a urine test done. And unfortunately, this case is greatly complicated by the fact that although Mr. McClain voluntarily submitted a sample, he thought the sample was sufficient. There's no fault of his in submitting something wrong or tampering with it. There's no fault of the officer. The officer takes that sample in accordance with procedures and sends it in. For whatever reason, when it gets to the lab, they start by testing it for alcohol. They find no alcohol in the test. When they finish that, they discover they don't have enough to test for drugs. So unfortunately, despite no fault of Mr. McClain, no fault of the officer, there wasn't a way to verify for sure, one way or the other, was he under the influence of marijuana. Because yes, it is common knowledge that if you smoked 2 weeks ago, it's possible you're going to have a low level of marijuana in your system, even if you didn't smoke anything since then. But it doesn't mean you're still impaired by it. Same thing with Adderall. The question then would become, is there a level of Adderall in the system? If there is it in accordance with a prescription? Is it in accordance with the fact that he's abusing it? And that next step, if that is, do the impairments we're seeing suggest Adderall use, or do they suggest something entirely different?
What relevance does the abuse of a prescription or no prescription have to the OBI charge? For instance, you could be prescribed something that impairs your ability, and if the state proves that that impaired your ability, could you not still be guilty of?
Correct. You can still be guilty of it. So you're right in that I'm saying, well, drug abuse, do you use it, do you not use it? I know there is a section in there that talks about were you taking a drug in excess in your prescribed rate. You're right, in this particular matter, it's kind of a red herring.
Because of what he was convicted of.
Correct. So it's really just the nexus between the two that any additional questions? If that's the case, then I thank you very much for listening to me this morning, and I would ask the court to consider the law and find that my client's conviction is against the manifesto. Thank you.
Thank you. Thank you very much for your presentation this morning. The court will take the matter under advisement, will issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which you can access through the 9th District website.